Hello, my name is Griffin Underwood, and today I will be presenting the case study for Chapter 9 in the Global Cyber Ethics course. My case study is the Communications Decency Act Protecting Social Media Companies. So, with that, let's take a look at the presentation. Welcome to the case study for the Communications Decency Act Protects Social Media Companies. My name is Griffin Underwood, and I will be going through my presentation with you today. So, a quick overview of the presentation. We'll be going over a summary of the case, the relevant laws that apply to this case, various terror attacks that unfortunately are relevant in this case, the lawsuits as a result of those attacks, the ethical dilemmas in the case, as well as a few case questions. So, to quickly summarize in 4 bullet points, the case revolves around 2 laws and how they relate to social media companies' liability for terrorist content shared on their platform. So the relevant laws in this case are the USA Patriot Act of 2001, as well as the Communications Decency Act, Section 230. So the USA Patriot Act is a comprehensive anti-terrorism law, and it was signed into law by President George Bush in 2001 in the wake of the September 11th terrorist attacks. In the law, victims of terrorism may sue and shall recover 3 times the damages that they sustained, including attorney fees. The Communications Decency Act, Section 230, states that no internet service provider shall be treated as the publisher or speaker of any information posted by another information content provider, for example, its users. So the CDA protects social media companies from being held legally responsible for what others say and do in their platforms. So unfortunately, this case involves 3 different terror attacks. The first is the 2015 Jordanian Police Training Center attack, and that's where 5 people died, including 2 Americans. ISIS claimed responsibility for the terror attack, and ISIS and its supporters promoted the attack on social media, and specifically Twitter. Families sued the Twitter for providing terrorists a platform, and we'll go over the results of this and the other lawsuits in a separate section of the presentation. Secondly, we have the 2015 Paris attacks, and this is where 130 people were killed by ISIS in 3 attacks in Paris, France. Only one of the victims was American, and that was Nohemi Gonzalez. The family of Nohemi Gonzalez actually sued Facebook, Google, and Twitter. And they questioned, were the social media companies doing a good enough job of removing hate speech from its platforms? And third, we have the 2016 Pulse nightclub shooting, and this unfortunately took place in Orlando, Florida, at a LGBT nightclub, and 49 people were killed and 68 people were injured. It's the second deadliest mass shooting that the U.S. has ever had. And social media of foreign terror groups allegedly inspired the shooter to commit this atrocity. The families of the victims collectively sued Facebook, Twitter, and Google. So next we will discuss the various lawsuits that resulted after these attacks. So first, for the Jordan attacks, the allegation was that Twitter was instrumental in ISIS's fundraising and recruitment efforts. The judge ruled that under the CDA, Twitter can't be treated as the publisher of terrorist propaganda. Now, the plaintiffs appealed this decision, and in 2018, the judge upheld the previous decision in a second ruling. So the second is the 2015 Paris attacks. The allegation in this case is that the companies weren't keeping terrorists from using their networks effectively, and specifically that social media sites placed ads next to extremist content and shared the revenue with ISIS. The ruling in this case is that the judge dismissed most of the lawsuit, but actually allowed the plaintiff to present more evidence of the social media companies' ad revenue going to ISIS. This case has not yet been fully decided and is ongoing as of November 2020. Lastly, we have the 2016 Pulse nightclub shooting. The allegations that Facebook, Twitter, and Google knowingly provided material support to a terrorist organization, and that social media from a foreign terrorist organization inspired the shooter. So for this case, the lawyers actually decided to do a new strategy, and they argued that since social media companies match user content with targeted ads, the companies themselves are actually producing their own terrorist content and profiting off of the terrorist users' content. And the ruling, again, the judge dismissed the case. That was in 2019. And they cited a lack of proximate cause on behalf of the companies. So there are a few ethical dilemmas in this case. First is, should social media companies be held liable for extremist content that's posted on their website? Second, should social media companies be profiting off of ads placed next to extremist content that is later removed? Most people would probably say no. Should digital content be treated differently than written content due to its velocity? And that's in the context of the USA Patriot Act and the CDA, which were both created before any kind of social media platforms were really popular. So there are two case questions. Are social media companies doing enough to limit extremist content? I would say that yes, they're doing as much as they can, because most social media platforms have both human content reviewers and machine learning algorithms that identify and remove content that violates their terms of use. And the fact that these companies have these safeguards show that they do take it seriously and they are taking steps to limit extremist content. However, as apparent in the 2015 and 2016 attacks, content is still getting around these systems. And the last case question is, should anti-terrorism laws take precedence over the CDA? Well, personally, I think that libel and copyright infringement are good applications of the CDA, but for extremist and terrorist content, social media companies should be held at least partially liable. In cases where the company is making every effort to remove the extremist content, the case should be looked at with a little bit more scrutiny, and less blame should be placed upon the social media provider. So I'm a little unsatisfied with the way that these cases turned out. Personally, I think that the social media companies should be held at least partially liable, because the terrorists have used their platform to spread their propaganda, and the fact that it's slipping through their human reviewers and the machine learning algorithms shows that it's really not up to par with the velocity and amount of propaganda that's being posted on the social media platforms. So no, I don't think that these cases should have been decided the way they were decided, but in the United States, we have a system where the judges rule based off previous rulings, and once one judge rules that no, the social media companies can't be held liable, then in 99% of the next cases, the judges are going to side with the social media companies, because in the past they've ruled that they're not liable. Well, I'd like to thank you for watching my case study presentation. My name is Griffin Underwood, and I hope that you learn something new about the Communications Decency Act and how social media companies are using provisions in it to get around being liable for victims of terror attacks. Thank you.